The next case to come before the court is in Ray Bpgp, and each side will have 15 minutes to present your arguments to the court, and the appellant has up to 5 minutes for rebuttal.
Thank you. I'd like to reserve 3 minutes for
That's
that.
fine.
I'm Susan Pritchard for the appellant, Greg Cronin. This case has a little bit of a complicated procedural background. The case did start off as a divorce, and the divorce was actually granted here in Summit County. There were 2 minor children. There were allegations that were raised actually during the divorce proceeding about mother's ability to parent these 2 children, so there was a referral to the juvenile court. Juvenile court did make some arrangements for the care of the children. Father got custody for a period of about 2 years or so. And then the case was back in domestic relations court subsequent to the granting of the decree on modification of child support. And actually there was an order that went on in the domestic relations court by agreement, whereby father agreed to pay the $800 per month in child support. In the middle of all that litigation, an issue came up about, well, are we in the right court? Should we continue in domestic relations court or not? There was some investigation into that, and it was determined that since the case had been out to juvenile court while the divorce was pending in relation to the children, that anything subsequent thereto needed to go back to juvenile court. So we were back in juvenile court, essentially on the child support issue.
Was that by way of stipulation or?
No.
No.
I was the attorney of record at the time. I raised the issue. In retrospect, maybe it would have been easier if I hadn't. But it had just happened to be in another case, and I thought we're going to go through all this and then determine that maybe this wasn't appropriate, so I better raise it now rather than later. So I actually raised the issue of, well, why is this case here? And my understanding is that once it's in juvenile court, it needed to stay there, and there had been motions filed. I may have even filed some of them, but back in the domestic relations court, unclear of who had jurisdiction, there was sort of a, as I recall, the magistrates or the judges spoke with each other and determined that it was appropriate for the case to be transferred out to juvenile court. So that's where we ended up. And there really was quite a dichotomy in the way that the case was being handled, because we had an order that went on in the divorce case post-decree about the issue of the discovery, which is tangential to the core arguments that I'll make today, but certainly did play into how the case worked out. We had done enormous discovery in the divorce, obviously, and so my position was, everybody's got all the information, here we are right again back. We don't need to do all this discovery again. It's extremely time-consuming and expensive, and everybody already knows what's going on with my client's business. So the court put in the domestic relations court put on an order said discovery is limited to tax returns. We have enough information. This is not talking about division of assets. Just give us the tax returns and we're done. So you'll see some allusions, they're not allegations because it did happen, but to the discovery problems that we had once we got out of juvenile court. Obviously I've got a recalcitrant client because he thinks that we already have a court order that says you're limited to tax returns, and now I'm being told I have to provide lots and lots and lots of stuff. So he wasn't real happy about that. So in any event, we finally get out in the juvenile court, we're doing the discovery, and there's a lot of stuff that goes on with that. But ultimately, when we come to the trial, we just stipulate. There isn't any testimony taken. The court is given the tax returns. And the interesting issue here, I guess, is that the tax returns for my client show that he was a W-2 employee. So for his own corporation, he runs a towing company. So it's easy to determine what his W-2 income is. And for each of the 3 different child support calculations that we have, one is about $27,000, I think one's at $29,000, one's at his income at about $35,000. So his income is way below the $150,000 equivalency arguments that come up later. Obviously, we also were aware that there were questions about what income is going to be included from his corporation into the child support calculation. Ultimately, at that hearing, where we stipulated the tax returns in, there was a request from Mother's Counsel to do a child support calculation based on $300,000 of imputed, well, not really imputed, but gleaned from the corporate tax returns as income to my client, and I objected saying, well, if you're going to do that, then you're going to have to put the information on the record about, I don't think I said standard of living, but case-by-case analysis that needs to be done if it's over $150,000 child support calculation. And nothing happened. The court didn't do it. And the court issued its, well, I won't say they didn't do it, but nobody took any testimony. There was no other information. Mother didn't testify, father didn't testify. We got the decision from the magistrate then, and this got a little bit complicated too, although I think it mostly got corrected, but the magistrate initially issued child support worksheets for, I think, it went back 5 years. And that wasn't the request. And so he had issued a magistrate's decision. There was an objection to that. And in the meantime, we had another hearing, and we all agreed and stipulated again to him that, no, we didn't intend for you to do the child support calculations back that far. Can you please issue another magistrate's decision only going back to July, I believe it was, of 2011. So he does. So then we get another decision and another round of objections. The big problem, I think, with this case is whether or not it's appropriate for the court to have extrapolated beyond the $150,000 equivalency. The actual child support worksheets that we have attached apparently have internally the ability to extrapolate. So we've got child support worksheet amounts that are way over the $150,000 guideline, and although the $150,000 equivalency would have been about, I think, in the range of about $1,800 a month. Instead, we've got child support orders that go on at about $2,500 a month. The court doesn't make any discussion, doesn't even say what the calculation would have been for $150,000. It's not in the record, it's nowhere. It's just the child support worksheet, here it is, with the extrapolation built in, so that, we apparently just did a straight line extrapolation of what it would have been based on the income, including all of the depreciation that wasn't excluded as business expenses from the corporate tax returns. So, under 3119.04, if the court was going to do a guideline calculation at the $150,000 or more of income for the parties, then it needed to consider the needs and standard of living of the children. There was nothing in the record on that. Now, we had had other hearings, that's true. The court was aware of some of the situation of the parties, but on the actual hearing on child support, there was no testimony, there was no information before the court on the standard of living.
May I interrupt you just for a moment to make sure that I'm clear on something, because when you started your recitation, you indicated that the court ordered that this hearing was going to be limited only to the tax returns in evidence, that no one was going to testify. And my understanding from reading the briefs was that that wasn't the court's order sua sponte, but that the parties agreed to that, and the court, with the agreement of the parties, limited the evidence to that. What are we going to find in the record?
Two different issues, Your Honor, and maybe I've just unnecessarily complicated things because I didn't really make this argument in my brief. I was just by way of background. When the case started out on the child support issue, we were in domestic relations. There were requests for production of documents. I objected. The court, the magistrate in our domestic relations court case, issued an order, which is in the record, that says no more discovery, we're done with discovery, we're going to be limited to the tax returns. Okay, that's where Susan, your client doesn't have to present or provide any more information. You've already just got done doing this in the divorce. All we're here now is about modification of child support. Mom had custody back because dad had custody. And so we're just, no more discovery, we're limited to tax returns. Then when the case went out to juvenile court, I brought that order up. I said, does this apply? I mean, it's totally unclear to me exactly how that works. Do these orders move over and are they still applicable? How does that work? And the answer was no, my client was required to provide all this documentation. Well, and as you can tell also from the docket, there was some difficulty in providing the information. There were requests and lots of information was provided. But when we came down to the final hearing, then by agreement, it's true. We just said, both parties just said, okay, here's the tax returns. You know, where nobody else is going to testify. There was a motion pending to exclude our expert and things like that, and at the end, my client decided he didn't want the expert. So I just said, Your Honor, I'm here to tell you, my client has determined we're not going to bring the expert. So you don't need to rule on the motion in limine because we voluntarily withdraw our expert. And here's the tax returns. So that's how that happened. I know it's a little convoluted. So that does raise the question, though, of who had the burden of proof, and the mother's the movement. What obligation does she have? What obligation did I have for my client? What obligation does the court have to say, well, I think we all knew he was going to be looking at corporate tax returns, but there was a broad range of what those numbers could be because his tax returns, all the tax returns showed that there wasn't money left over in the corporation unless you considered the depreciation allowance as income, without excluding it as an ordinary necessary business expense. So in the end, we get a decision that doesn't address, it's using it didn't even use the $150,000 equivalent. It extrapolated to some other number that was apparently internally resulting from whatever program the court was using to do the child support calculation. So my client's position then on this is that really the court needed to consider the standard of living, the needs of the children, and actually of the parents before making the child support. The other issue that I raised, well, I should mention this for the court too. There were actually two appeals that were consolidated, and it is true that the case number 27-541, we did not file any brief in relation to that case as determined there was no cognizable issue. So I do not object to dismissing that
Appreciate that.
Yeah. So the other issue then is in relation to whether or not the court could make the order retroactive.
And you're already entering in your own time.
Oh, okay, then I will.
It's up to you. Okay.
That's fine, I will withdraw my time.
May it please the court, I'm Charles Buddy and I represent the appellee in this case, Jennifer Prunty, who is the mother of the children that are subject to the child support in this case. First, I'd like to address some issues raised by Judge Moore with regard to the history of the case. There was initially in the domestic relations court essentially a discovery order. Once the case was transferred to juvenile court, the juvenile court found that they had exclusive jurisdiction and that any of the proceedings that had preceded it in domestic relations court were done without jurisdiction, and therefore that the discovery order that was there was null and void because it was entered without jurisdiction. Then the juvenile court proceeded to issue its own discovery rulings as discovery proceeded in the juvenile case.
Okay, just so I understand, you just said that the parties stipulated.
They do, and that all happened before, and then when it comes time to trial, the parties did, after all the discovery fights that had gone on, at the day of trial, the parties stipulated to submitting the tax returns and the other stipulations that were entered on the record that are present in the transcript was the only evidence submitted to the court, and both parties requested the court to determine their child support calculation based upon the evidence that was presented. Now, with the tax returns being the only evidence presented to the court, under Revised Code Section 3119.01C9B, it specifically excludes depreciation taken on tax returns as being an ordinary and necessary business expense for a business. So tax return depreciation is excluded by statute and should be added back into gross income. Part A of that provision, 3119.01C9, states that depreciation that represents actual cash expenses and are on the books of the business can be deducted from gross income. Well, in this case, all we had was tax return depreciation. So that had to be added back into the gross income of father for income available for child support. There was no evidence presented of actual cash expenditures for any of the years presented or the books of the business for what depreciation expenses were on the books of the business for any of these years presented. And in New v. New, the 3rd District case, and I believe Camp versus Camp, both state that absence of evidence regarding actual cash expenditures or depreciation on the books means that that depreciation is added back into the business owner's income for child support purposes. That is exactly what the trial court did here. They took the depreciation expenses and added it into his gross income for child support, followed the statute to the letter. There was no evidence to the contrary, and it issued a child support order using the 3-year average of income with all of the depreciation expenses added back. Next, I'd like to address the arguments counsel made with regard to the child support amount in excess of $150,000, provides code section 3119.04B. First and foremost, the trial court did not address this objection at all. It was not raised in the original objections filed within the 14-day objection period. It was raised only in a memorandum in support, which was filed after the 14-day period and after the transcript had been filed. There was no motion for leave to supplement objections to add a new objection to the list that was originally presented. And then when the trial court addressed the objections posed by father, it identified the 4 objections that were written in the original objection sheet within the 14 days and did not address the argument regarding 3119.04 at all. And I submit to this court that the trial court chose not to address this supplemental or additional objection because it was not filed within the 14-day period, and that it is in the trial court's discretion to do so. And specifically in support of that, I would cite to Mustard v. Mustard, a 12th District case in which a court rejected objections that were raised in a memorandum in support. And similarly, in Beasley v. Beasley in the 4th District, the court rejected new objections that had been raised in a memorandum in support that had not been originally and specifically objected to within the appropriate 14-day period.
No, so the court did not say that.
The court did not in this case, the court did not specifically address it and say I specifically reject this proposition, but it clearly did not address that argument at all, and I do not believe it's an abuse of discretion to not address that argument, and I would submit that that argument has been waived. Now, assuming arguendo that this is before the court at this time to discuss, I do believe that there is enough evidence in the record to support the trial court's finding on the extrapolation method. First, the extrapolation method by itself is not an abuse of discretion in determining incomes that are above $150,000. The Bunkers case and the Kendall case, both cited in my brief, state that nothing in the statute precludes a court from using an extrapolation method as long as there is enough evidence to support a finding on a case-by-case analysis under 3119.04B. Now, in this case, there is limited evidence before the court, I will admit to that, but there is evidence that can support a finding that above $150,000 guideline amount is appropriate and proper in the best interest of the children. To that end, the court knew, number one, the parties' incomes. There is a gross disparity of incomes between the parties in this case, where the court found that father's income ranged somewhere between $180,000 and $210,000 a year, and mother's income was between $2,500 and $5,500 a year for the 3 years in question. Disparity in income is cited in other cases involving incomes above $150,000 as one of the reasons that you can issue child support above the $150,000 guideline. Second, there's a stipulation in the record that the minor son had medical issues. He suffers from hemophilia, ADHD, has some medical needs that are extraordinary, and has caused significant health issues for the son throughout his life. Third, the court knew, and there's a stipulation, that the son was receiving supplemental Social Security income benefits during the pendency of this case, and SSI is available to disabled children. So the court would know that the minor son, in addition to the medical diagnoses, has been declared disabled under government standards. I would submit that that information enough is sufficient for the court to order child support above $150,000. Further, this case in Zeitler v. Zeitler, or this court in Zeitler v. Zeitler, and other courts in Bunkers and Kendall have both stated that in a case where a court issues a child support order above the $150,000 guideline amount, it is not required to explain its decision at all. There is no requirement to do so. The only requirement in the statute for the court to justify or explain its position is when it orders support that is less than the $150,000 guideline amount. So the court in this case was not required to state that it had considered this and that or had determined the $150,000 guideline amount. It is absolutely not required under the statute. So the court did not abuse its discretion in just issuing an order with the guideline amount as such and the extrapolation method that's there. And there is enough evidence for this court to at least infer that the court had sufficient evidence to make its decision. In Zeitler, this court had stated that the appellate court need only find a reasonable theory for the trial court's conduct in order to find that the court did not abuse its discretion. And I believe that the facts on the record, in the transcript, and with the tax returns is enough to find a reasonable theory for the trial court's conduct in extrapolating a straight line to what the father's actual income was and issuing child support based on his income for that amount. Third, in the appellant's brief, she raises the issue of the retroactive date of the child support order in this case. I would submit that that issue was absolutely not raised in the objections or in her memorandum in support. And under Juvenile Rule 40D3B, the failure to raise that issue in the objections to the magistrate decisions waives that issue on appeal, and I do not believe that it is appropriately before this court to decide that issue in this case, with the reservation that plain error may be asserted. I do not believe plain error has been asserted, and in any event, this is a due process argument, and due process can be waived, and I believe that a father has waived that argument by failing to raise it in the trial court. So I submit to the court that the trial court's judgment entry should be affirmed in total, because there was no evidence to support that any of the depreciation should have been deducted from father's gross income, that there was sufficient evidence to support a finding of child support in excess of the $150,000 guideline amount, and that the court was not required to explain its rationale in any event regarding that, so there was no abuse of discretion in the trial court's actions in this case. And I would also request this court find that father has waived his argument with regard to the due process argument, as well as the 3119.04B argument, since the trial court did not address that issue in its judgment entry and was not required to do so based upon it being raised for the first time in a memorandum of support. Thank you, Your Honor.
Child support, after all, is intended to be set in an amount that is in the best interest of the child or children. In this case, ordering too much child support is as bad as not ordering enough. The Social Security SSI that one of the minor children was receiving is true, but mother was receiving that money. And that should be something that would be taken into account. My client wasn't receiving it, mother was receiving it. I have
Was that
seen...
raised below?
I'm sorry?
Was that raised before the magistrate?
Yes. That's one of the assignments, one of the objections was that issue.
How about these other issues that counsel indicates were not raised that you've argued on appeal?
Well, I think there's two things going on. The first one is the question of the $150,000 equivalency that was raised. It's raised both on the record before the magistrate, and it's raised in the supplement to the objection. I don't know of there isn't any case I'm aware of that out of the 9th District that addresses specifically how that works. The two cases that he cites are not from our district, and the rules are slightly different. We do have a local rule that allows you to supplement your objection, which I did, and that entire objection is in relation to the $150,000 equivalency. The court didn't address it, that's true, the trial court, other than to say father's other objections are rendered moot by the decision and therefore dismissed. She doesn't say what they are, but she's saying father's other objections are rendered moot. So But there's no discussion by the trial court on that issue. I understand the rules to be such that you're to bring these issues to the trial court's attention so that they have the opportunity to rule on it prior to it being received in the Court of Appeals. We certainly did that. We brought it to the court's attention both before the magistrate and to the court in the supplement. So to say that on that ultra-technical detail that the court didn't have the opportunity to address it, well, they did, and it didn't happen.
Well, what about the argument that it would have been within 14 days? In other words, if you are allowed to supplement and raise new objections that weren't in the original objections, then you've just basically made up your own time limit.
Made what?
Made up your own time limit, basically.
Oh, well, I mean, this case is limited to one issue, which is child support, basically, right? So I would say the answer to that is you need to bring to the court's attention in the objection that you are objecting to the child support. And the basis for it, there could be multiple bases for the objection. A lot of times we have decisions that deal with multiple issues, and I don't know that you're ever required to fine-tune it to say what's wrong with the child support necessarily. There's an error in the way that the child support was calculated. We brought that to the court's attention. The fact that then later there are multiple bases for saying that the child support is wrong, I don't understand why it would be inappropriate to potentially raise that in a supplement to the objection. And since there's no rule and no case law that tells you one way or the other, I don't, outside from some cases that are now outside of our jurisdiction, how one would be guided in that direction and knowing how to approach that.
So I'm sorry, your time is up.
Okay, well, thank you very much.
Thank you. Thank you both for your presentations, your arguments in court. The court will take the matter under advisement and issue a written opinion, which will be sent to you as well as you can look on the website.
Thank you, Your Honors.
Bye-bye.